And that argument then falls flat for the applicant to say, but his wishes was that he needs to go back. He was repatriated. Then it leaves them with the second argument of a pleaded agreement. Now, the pleaded agreement we find on paragraph 7.10 of the founding papers. K19. Case lines, page K19. They say, on the 10th of June, so they fixed the date and time of this agreement. We must know when there's consensus, when there's a meeting of mind, if you want to plead an agreement. Waterfalls, the delegation went with the representatives. The seventh respondent again acted as the family spokesperson, and substantial progress was made during this meeting. The following was agreed. So they fixed the point there of the agreement, the purported agreement. And then they list the terms there, which they then say one of them was, 7.10.4, the President of Zambia would preside over the state funeral, and the Catholic Archbishop, Dr. Alec Banda, would celebrate the Mass. Now, we go to the answering affidavit, and we see that that's denied, that 7.10.4 would ever be a term of that agreement. It's denied, expressly denied in the answering affidavit. And taking a contextual approach to the matter of pleading the agreement, we know why it's denied because of the treatment of the late president. We can understand why he would deny this. Taking into account all the issues that he had with the current president and all the instances where his freedom was taken away, all the criminal matters that were brought against his family, we can understand why that is a pertinent material fact that the family will not budge on. And then we need to compare FAA 7 with EL 16, because FAA 7 is the one that was referred to in the founding affidavit incorrectly, that was prepared by the applicants. That one was prepared, in fact, by the respondent. And then in the replying affidavit, they agreed that that was a mistake. It was prepared by the respondent, the typed version. And that's the version when the court correctly found that, but it's not a final version of an agreement, because even at the bottom it says parties will consult and agree on who speaks.
I'm sorry to interrupt. There was no finding. We made no finding.
Oh, comment. Sorry, as the court pleases, my lord. Incorrect referencing. But where there was a comment that says parties will consult and agree on who speaks at all event. Clearly, it's not finalized. All those issues in FAA 7. One then sees the proposed agreement that was handed to the respondent, EL 16, which differs from FAA 7. So FAA 7 would be the version of the respondents, and EL 16 at that stage would be the version of the applicant. Now, if those two don't coincide, there's definitely no meeting of minds, and there's no consensus. There can never be. There's objective proof that it can never be. So EL 16 specifically says, at that second paragraph, upon arrival, I can't make out that word, but the old wing, the President of the Republic of Zambia will receive the family and the military as much in the conflict. And then there's a further paragraph, subparagraph A, the President of the Republic of South Africa, Zambia, will lay the wretch on the proceedings. And then they differentiate between dignitaries and the President by visiting by all dignitaries, but they differentiate in A, and that's a subparagraph, between the President and dignitaries. So you cannot even take it that dignitaries just simply includes the President. This is their version. They make the differentiation between dignitaries and the President.